An unprecedented spectacle in judicial history, 12 fatal questions ripping open the cracks in the legal legitimacy of the Miles Guo case. 1. Regarding the accuracy of the $1.3 billion loss amount. Prosecutors, your own expert witness, Paul Hinton, admitted that the $1.3 billion loss was merely a simple aggregation of total funds flowing into entities without any funds tracing whatsoever. How can such a crude algorithm become the standard for a legally recognized actual loss? Is this an attempt to mislead the court or a challenge to the seriousness of the law? 2. Acquitted, yet the money is still counted. The double standard of $401 million in the GTV case. The jury clearly acquitted Mr. Guo of the charges related to the GTV private placement. So why, prosecutors, do you still forcibly include this $411 million alleged loss in the sentencing calculation? This is a blatant violation of the clear provision to exclude acquitted conduct in the 2024 sentencing guidelines. Are you challenging the jury's verdict or playing games with fundamental judicial procedures? 3. Questions from 7,000 non-victims. Prosecutors, where is your materiality? Over 7,000 investors have formally declared that they were not deceived and reject the victim label. Prosecutors, when such a vast group denies being victimized, how can the core legal element of materiality of misrepresentation in your conviction theory still hold water? Does this not completely undermine the very foundation of the charges? Self-correction, completely undermine is slightly stronger than pull the rug out from under. 4. Why did over $200 million in redemptions evaporate? Prosecutors, the Himalaya Exchange clearly paid out over $200 million in real redemptions to customers. According to sentencing law, this amount should be deducted from the so-called total loss. Why do you turn a blind eye and refuse this offset? Is this blatant financial manipulation or a deliberate overstatement of losses to achieve a harsher sentence? No change needed. This is already very strong. 5. 95 million double counting. Is the government's ledger a mistake or a fraud? Prosecutors, ironclad evidence shows that your financial summary, GXZ26, contains an incredible double counting of up to $95 million. The same funds were counted twice. How can this summary sheet, filled with such serious errors, possibly prove it did not intentionally mislead the court? Is this financial negligence or the deliberate creation of false evidence? Self-correction. Such serious errors is a slight emphasis. 6. CCP's 9-tool project. How much victim evidence has been contaminated? Prosecutors, the Department of Justice itself confirmed in United States v. Bai that the CCP operates the 912 Special Project Working Group aimed at discrediting Mr. Guo. Have you seriously investigated the extent to which the so-called victim evidence in this case has been systematically manipulated by this state-level smear campaign? How do you ensure this evidence wasn't fed or even outright forged by the CCP? 7. The core witness. Being complained, is Yi Jianhu's testimony voluntary or coerced? Prosecutors, the evidence is as solid as a rock. Defense witness 1, Yi Jianhu, was interrogated by national security agents in Shanghai for 11 hours and then forced to use a police-provided template to submit false reports to the FBI and SEC? Does your government admit that complaints produced under such state coercion lack legal authenticity and voluntariness? The deeper question is, how many more of your so-called victims are like Yi Jianhu, forced to submit false reports out of fear of CCP retaliation? 8. Ironclad evidence of CCP's smear template. Is American justice being manipulated? Prosecutors, Mr. Wan Shengcheng has provided photographs of a smear campaign template handwritten by a Chinese national security official, the content of which is highly consistent with multiple complaints submitted to the U.S. government. What explanation does your government have for this state-sponsored physical evidence directly interfering with U.S. judicial proceedings? Is this not ironclad proof of the Chinese government's naked infiltration and manipulation of the U.S. justice system? 9. Regarding extreme sentencing disparities. 27 months to life imprisonment. Is this law or politics? Prosecutors, the Judiciary Sentencing Information Database, JSIN, shows that the average sentence for similar cases is only 27 months, yet you suggest life imprisonment for Mr. Guo. What is the legal basis for such an extreme and disparate sentencing recommendation? Is this based on impartial legal standards or other political considerations? 10. Framing via fire. Mr. Guo was in custody, and the FBI pulled the surveillance. How does the government explain this? Prosecutors, when the fire broke out, Mr. Guo had been in complete FBI custody for several hours, and the FBI proactively unplugged the apartment's surveillance during the search. In the face of this ironclad evidence, what is the factual basis for the government continuing to imply Mr. Guo was responsible for the fire? Is this a blatant frame-up or a cover-up for the FBI's illegal actions? 11. The cloud of victim identity. Under CCP coercion, how does the government independently verify true intent? Prosecutors, since there is definitive evidence of the CCP's large-scale coercion of investors to submit false complaints, have you conducted any independent verification of the true identities and intentions of the thousands of so-called victims? If the verification standard is merely mechanical fund inflows, how can the government guarantee the sentencing process hasn't been hijacked by the CCP's transnational repression and used as a tool for political persecution? 12. The ultimate interrogation of prosecution legitimacy. Is this a political trial hijacked by the CCP? Prosecutors, the core victim complaints in this case, have been proven to be political products of CCP coercion. After accounting for redemptions and remaining asset value, the so-called fraud amount in economic substance approaches zero or is even negative. Furthermore, the 18 SC 322 unsealed opinion has confirmed the bribery of an internal DOJ lawyer and illegal lobbying by the CCP. Facing this series of ironclad facts, where exactly is the legal factual basis for the filing of this case? How do you prove that the current prosecution is not a naked extension and disguised execution of the CCP's 9-1-12 project within the U.S. justice system? Is this a trial based on legal facts or a political persecution controlled by the CCP?